Hello and welcome back to this YouTube channel. Today we are going to discuss about the current affairs of polity and governance. This would be the last discussion of polity and governance. It is current affairs from last 1 year. Recently, these topics which we are going to discuss today, they were in the news from last 1.5 month. So I felt that as UPSC postponed its exam, that it was necessary for me to get to these topics and bring these topics to you guys so that it would help you prepare well. Maybe UPSC may ask some questions from these last mile chains. Now, without wasting any time, let's move to the topic. Here, uh, when we will go through these, subtopics of today's discussion, if you had seen my channel, if you are the continuous viewer of these videos, you would find out that most of the topics which we are going to discuss today, we had already discussed them in detail uh, in other videos. So today we are just going to give a little touch up to these topics and try to understand what were the new outcomes regarding these topics. So without wasting any time, let's move to our first topic of discussion. It is Uniform Civil Code. Why it was in news, as we can see it here, the Uttarakhand State Legislative Assembly, they passed the Uniform Civil Code Uttarakhand 2024 bill. About Uniform Civil Code, if you are the serious aspirant, you would know Article 44 of the Indian Constitution, the DPSP, that the government should opt for Uniform Civil Code in the future. When the Constitution was framed, the framers of the Constitution, they discussed about it, but at that time they did not found it viable that they should opt for this Uniform Civil Code. They feared that it would further break the country, as we had during our independence, we had already seen the huge breakdown of the Indian of our country. So there were many concerns then which the framers addressed, which the framers discussed, and so they kept it in DPSPs. And this they knew that one day will come when states will opt for this uniform civil code, and they kept it in DPSPs, that when we mature enough someday, and when the government feels it, that the time has come and they would implement it. So this uniform civil code, it is something which is inevitable in the near future. You would see it, a state after state adopting to it, and finally one day will come and it would be implemented throughout the country. So regarding this, let's discuss more about it and see what does this discussion in what does this PPT give us regarding the uniform civil code. About the news, we can see here that Uttarakhand became the first state in the country to pass a law on uniform civil code, and also we should note that Assam and Gujarat, they are also working on the implementation of UCC. And also we can say that the Goa is the only place where a form of a common civil code is in practice, that is Portuguese Civil Code of 1867. What are the key highlights of the Uttarakhand Uniform Civil Code? Let's see. Its applicability. It applies to all residents of Uttarakhand except the tribal community, those protected under Part 21 of the Constitution. Here, what are the few elements? Marriage and regarding marriage and live-in relationships. It mandates registration of all live-in relationships within 1 month and marriages within 60 days. It is applicable to all residents, excluding the LGBTQI plus community. It grants legal recognition to the children from voidable marriage and live-in relationships, as this is seen different in different laws. Also, it criminalized some of the marriage practices, like it banned the halala, which is the practice in Sunni Hanafi Muslims, and it also prohibited the bigamy or polygamy, which is also the practice mostly found in the Muslim community. And also regarding inheritance, it ensures equal property rights for sons and daughters, departing from the co departing from the earlier system where we had seen there was the discrimination in the Indian society that women were not given any inheritance rights. Moving forward, let's see what this gives us. A UCC, it provides for the formulation of one law for the entire country, which would apply to all religion communities in their personal matters such as marriage, divorce, inheritance, adoption, and succession. Currently, Indian personal law is complex, which with each religion adhering to its specific laws. We should know that there are different personal laws for different religions, so it increases the complexity of the law. For example, we have personal laws in India like Hindu Succession Act 1956, which governs Hindu, Sikhs, Jains, Buddhists. Then we have Muslim personal law, which governs Muslims. Then we have Indian Succession Act 1925, which applies to Christians, Parsis, and Jews. Then the Special Marriage Act, which provides for this solemnization of interfaith marriages as well as registration by a marriage officer. Moving forward, now let us discuss the second important article which was recently in news. It is about the Citizenship Amendment Rules 2024. Regarding this, let us discuss what these slides bring us, what are the important information which we should gain from it, what are the points which we should remember, what may come in the exam. Let us discuss about that. Here we can see that the Ministry of Home Affairs, they have amended the citizenship rules 2009 and notified citizenship amendment rules 2024 to enforce the Citizenship Amendment Act 2019. Here, if this topic is now old, is very old, and if you are even 25% serious aspirant of the UPSC, you would know it very properly about the Constitution Amendment Act 2019. So we don't need, and we had already discussed it earlier, so there is no need to discuss it in depth. So let's get some important points which are necessary here. So moving forward, we see it here that by exercising power under Article 11, the Parliament passed the Constitution Amendment Act 2019 and received the President's assent in December 2019. However, we can see that the Ministry of Home Affairs had not framed the rules, so the act could not be implemented. The Constitution Amendment Act aims to give citizenship to the target group of migrants even if they do not have valid travel documents as mandated in the Citizenship Act of 1955. Moving forward, let us see about Citizenship Amendment Act 2019. Few important points in it. The amendment provides that illegal migrants who fulfill four conditions will not be treated as illegal migrants under the act. The conditions are as they are Hindus, Sikhs, Buddhists, Jains, Parsis, or Christians. They are from Afghanistan, Bangladesh, or Pakistan. They entered India on or before December 31st, 2014. And also, they are not in certain tribal areas of Assam, Meghalaya, Mizoram, or Tripura included in the sixth schedule to the constitution, or areas under the inner line permit, that is Arunachal Pradesh, Mizoram, and Nagaland. The central government exempted the said migrants from the adverse penal consequences of the Passport Act 1920 and the Foreigners Act 1946 and rules or orders made thereunder. These provisions, these which we see here, this was the main concern. Because of that, the whole hue and cry was about this act, which we already know. The period of naturalization has been reduced from 11 years to 5 years for the above category of migrants, and also 5 grounds for cancellation of overseas. Uh, we know that OCI registration, the Act provides that the central government may cancel the registration of OCIs. Grounds for cancellation of the overseas overseas citizens of India. So let us discuss more about it. What are the five grounds of cancellation of overseas citizens of India? First, we can see registration through fraud, showing disaffection to the constitution, engaging with the enemy during war, necessity in the interests of sovereignty of India, security of the state or public interests, or if within 5 years of registration the OCI has been sentenced to imprisonment for 2 years or more. What are the key highlights of the Citizenship Amendment Rules 2024? We can see here the eligibility to apply for citizenship by registration, naturalization. One must be a person of Indian origin, married to an Indian citizen, a minor child of an Indian citizen, a person whose parents are registered as an Indian citizen, person or either of his parents was a citizen of independent India, registered as an overseas citizen of India, card holder. Other qualifications for citizen by naturalization or applicant will have to present an affidavit verifying correctness of the statements made in the application and an affidavit by an Indian citizen to testify the character of the applicant. Applicant must have adequate knowledge of one of the languages listed in the 8th schedule of Indian Constitution. Proof of nationality rules laxed the requirement of documents to prove the country of origin. Applicants now can provide 20 different documents as proof of entry into India, including visas, residential permits, census slips, driving license, Aadhaar cards, etc. Renouncing citizenship of another country, applicant shall have a declaration saying that citizenship of his country shall stand renounced irrevocably if the application for Indian citizenship is approved. Authority to which application may be made under Section 6B of the Citizenship Act 1951, an application shall be submitted in electronic form to the empowered committee through the district level committee as may be notified by the central government. These were the few key rules of the Citizenship Amendment Rules 2020. Now let's move to the third topic of today's discussion. It is related to municipal elections as this topic was in a red hot form as we had seen that the Supreme Court invalidated and annulled the outcome of the mayoral elections held for the Chandigarh Municipal Corporation. This news went viral even the people who are not even the aspirants who are not aspiring to be the civil servant they know about this news. So this is not uh, such news that which we don't know. This went very much viral. You might have seen the video of that officer who was counting the votes that went very much viral. So this is regarding that only. Moving forward about municipal elections, we should know that municipal elections refer to the elections held to elect representatives for local urban governing bodies. Elections for the municipal corporations are held as per the Municipal Corporation Act framed by the legislature of the respective state government, whereas elections for the municipalities and the town panchayats are held as per respective municipal act. Moving forward, what are the constitutional provisions related to municipalities? Composition of municipalities, Article 243, or all the seats in a municipality shall be filled by persons chosen by direct elections from the territorial constituencies in the municipal area. For this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. Then also we can see here reservation of seats. Article 243D, seats are reserved for weaker sections, scheduled caste, tribes, women and other groups as per respective municipal acts. Duration of municipalities here Article 243U, 5 years for the date appointment for its first meeting. Election to constitute a municipality are required to be completed before the expiration of the duration of the municipality. If the municipality is dissolved before the expiry of 5 years, the election for constituting a new municipality are required to be completed within a period of 6 months for the date of its dissolution. So before the expiration of the term, the elections for the municipality should be held, and if the municipality is dissolved before the expiry of 5 years, then the election for constituting a new municipality should be done within a period of 6 months from the date of its dissolution. About State Election Commission Article 243 ZA, the superintendent's direction and control of the preparation of electoral rolls for and the conduct of all elections to the municipality shall be vested in the State Election Commission. So I have that kind of gut feeling that a question regarding a state election commission may be asked in this year's prelims exam. In somehow, this state election commission would be mentioned in our paper. So I have this feeling. I don't know what question would be. So I request you guys to please read about it. Remember a few important points we had already discussed about state election commission earlier, and review those points, see what is the functioning of the state election commission and how does it work. About urban local bodies, we should know a municipal corporation has three authorities. They are the council, the standing committee, and the commissioner. The council, comprising councillors, is the deliberative and legislative wing of the corporation that is headed by a mayor. He is assisted by a deputy mayor. Though the mayor is an ornamental figure, he is recognized as the first citizen of the city. Then we have the standing committee. Committees were created to facilitate the working of the council, which is too large in size. The municipal commissioner is responsible for the implementation of the decisions taken by the council and its standing committee. Also, Indian cities largely follow the commissioner as chief executive, which is CAC, commissioner as chief executive model, as opposed to the directly elected executive mayor model. Directly elected executive mayor model, it is a strong mayor model where a mayor has extensive executive power. In commissioner as chief executive model, it is a weak mayor model where the executive power lies in the hands of the commissioner and Indian administrative service officer. Then every state in the country has enacted legislation for the constitution of the municipalities in the state, specifying their function, structure, resource, and their role in civic administration. Moving forward, about the new topic, which is SR Bommai judgment. Even if you had only open you had read your polity books, I swear I am very much confident about that you would have read about this judgment. Whether you know the background, whether you know the story about it, but this SR Bommai judgment, this 1994, it is very important and you would often hear about it. So today let's discuss about it. Let's see why this judgment is important, why it is often mentioned in our textbooks, and what does it say to us about SR Bombay judgment 1994 of the Supreme Court. Why it is important, because it completed 30 years. It would complete 30 years in 2024. So here is a bad news for the people who were born in 1994, that they are also 30 years old. About SR Bommai versus Union of India 1994 judgment, here we can see in 1989 the central government dismissed. About its background, in 1989 the central government dismissed SR Bommai's government in Karnataka under Article 356 of the Constitution, and President's rule was imposed. Then they went to the court, and a nine judge bench of the SC interpreted Article 356 of the Constitution to define the contours of the proclamation of President's rule, whether this imposition of President's rule was valid here, or it was the overreach of the central government. So let's discuss about. First, we would read a little bit about Article 356. About Article 356, State emergency is it deals with the state emergency, which is also known as president's rule or constitutional emergency. The constitution does not use the words emergency for this situation. Article 356 finds inspiration in section 93 of the Government of India Act 1935. Ground to declare based on the report that from the governor of a state or otherwise, if the president is satisfied that a situation has arisen in which the government of a state cannot be carried on in accordance with the provisions of the constitution. So here a question may be asked that if the president, is it necessary for the president to impose a presidential rule, is it necessary that governor should recommend it? So here we can see that based on the report from the governor of a state or otherwise. So it is not only that the governor should notify to the president that the state is not working in accordance to the constitution, so please bring the presidential rule here. So only the governor's recommendation is not important. About validity, the president's rule is valid for 2 months unless parliament extends it for up to 6 months. Extensions beyond a year are only permitted in a national security emergency or if the election commission certifies that holding assembly election is difficult. Even then, the limit for the president's rule is 3 years. Moving forward, what were the few about SRB's case? We should note that what were the few questions which were asked in this case. One, the questions were one, whether the proclamation of the president's rule were justifiable, liable, are they liable to judicial review? Second, the scope and limits of the president's power under Article 356. The Constitution is silent on what constitutes a failure of constitutional machinery, making the provisions vulnerable to misuse. And the third question, which was asked, what are the consequences if the court holds the proclamation of the president's rule invalid even after the parliament has given its approval? What if the courts make it invalid and the parliament has already approved it? What would be the consequences of it? First question was, is the proclamation of the president's rule, is it justiciable? Like, is it applicable to judicial review? Second, the scope and limits of the president's power under Article 356. And the third question was, what are the consequences if the court hold the proclamation of the president's rule invalid and as already parliament has given its approval, what would be the consequences? About this, let's see what the Bombay judgment gave its answers and what are the key principles laid down. About judicial review, SC declared presidential proclamation under Article 356 is subjected to judicial review. It is subjected on substantial grounds. No restriction on the court for examining the material based on which the president formed his satisfaction. So it is justiciable. It is available for the judicial review on substantial grounds. There is no restriction on the court. Then about the SC or High Court or Supreme Court can strike down the proclamation if it mollified or based on wholly irrelevant or extraneous grounds. The Supreme Court or High Court can strike the proclamation down. And the limits of about limits of the president's power, the verdict concluded that the power of the president to dismiss a state government is not absolute. The president should exercise the power only after his proclamation is approved by the both houses of the parliament. So this power is not absolute for the president. He has to do it only after this proclamation is approved by both houses of the parliament. Till then, the president can only suspend the legislative assembly by suspending the provisions of the constitution related to the legislative assembly. And further, whatever the consequences of the invalidation of president's rule, both the council of ministers and the legislative assembly should stand restored, and the laws which were made or passed and the audiences passed by the during the presidential rule will remain unaffected. Further, other key observations This laid down the supremacy of the floor test in determining the support enjoyed by the party in power. The use of Article 356 was justified only when there was a breakdown of constitutional machinery and not that of the administrative machinery. And also based on the Sarkaria Commission Report 1988, the Supreme Court in this case has enlisted where the use of the exercise of power under Article 356 could be proper or improper. For proper use, examples are constitutional directions of the central government is disregarded by the state government. Improper use, examples are state government is not given prior warning to rectify itself except in case of extreme urgency leading to disastrous consequences. Secularism, democracy, and federalism are the essential features of our constitution and are part of its basic structure. An attempt was made to define secularism. It is more than a passive attitude of religious tolerance, it is a positive concept of equal treatment of all religions. Moving forward, what was the impact of SR Bombay judgment? It had huge impact as we can see before from between 1950 and 1994 the president's rule was imposed 100 times or an average of 2.5 times a year, and from 1995 to 2021 it has been imposed only 29 times or a little more than once a year. Then it also helped in strengthening the federalism. The judgment made Article 356 proclamation justiciable without undermining the president's discretionary power, thus strengthening India's federalism without diminishing its separation of powers. Moving forward, let's move to the important article of today's discussion, which was recently in news. I guess in from the last 1 month, this is in news. It is about the sixth schedule. Why it was in news? Because of the Ladakh, the people of Ladakh, they are protesting for Ladakh to be recognized as a tribal area under the sixth schedule. Here, what the Ministry of Home Affairs they argued that the granting sixth schedule status to Ladakh necessitates a constitutional amendment, which is a complex process. During a meeting with the Ladakh representatives, the Union Home Minister proposed extending Article 371 like protection to the region. Moving forward about sixth schedule, the sixth schedule of the Constitution under Article 244 and Article 275 of the Constitution is provided for the administration of tribal areas in Assam, Meghalaya, Tripura, and Mizoram. The provisions of the sixth schedule it empowers the governor to create autonomous district councils and autonomous regional councils in these four states. Composition of ADCs: ADCs consist of not more than 30 members, out of which 4 are nominated by governor while the rest are elected. Bodoland Territorial Council is an exceptional. It can have up to 46 members in ADCs. This is the exception from other ADCs. And about ARCs, if there are different scheduled tribes in an autonomous district, the governor may divide the area or areas inhabited by them into autonomous regions. The sixth schedule conferred the following executive, legislative, and judicial powers to ADCs and ARCs. Let us discuss about that. What are the legislative powers? To make rules in respect of lands, management of forests other than reserved forests, shifting, cultivation, chiefs or headmen appointment. In respect to inheritance of property, marriage and divorce, and social practice, regulations and control of money lending or trading by any person other than scheduled tribes residents in that scheduled district. About executive powers: power to establish or manage primary schools, dispensaries, markets, cattle pounds, fisheries, roads, road transport, and waterways in the district. The councils are also authorized to prescribe the language and manner of instruction in the primary schools. About judicial powers: empowered to constitute village and district council courts. No other courts except the high courts and the Supreme Court has a jurisdiction over such suits or cases of the council courts. However, these council courts are not given the power to decide cases involving offences punishable by death or imprisonment for 5 or more years. About financial powers: empowered to prepare a budget for their respective councils empowered to assess and collect land revenue and impose taxes on professions, trades, etc., given the power to grant licenses or leases for extraction of minerals within their jurisdiction. These are few legislative, executive, judicial, and financial powers given to ADCs and ARCs. So here, one thing we should know that UPSC does ask such questions where they can make us compare the fifth schedule and sixth schedule. There are few important points which we should know about the applicability of the fifth schedule. It applies to certain tribal areas in any states of India, currently in 10 states. About sixth schedule it applies to the tribal areas in the four northeastern states of India. About administration, tribes advisory council, here we have district councils or regional councils, which we already discussed. About administrative power, tribes advisory councils or TACs being the creation of the legislative assembly of the states has limited powers, which are mostly executive. About ARCs, about the sixth schedule, extensive powers including executive, legislative, which we already discussed, judicial, all delivered from the constitution. Here, what does it emphasize? Or it emphasizes more on protection of tribal rights. Here in the sixth schedule, we see more on self-governance. Does PISA Act 1996 have any application? Does it apply in fifth schedule? Yes, it does. It does. PISA Act to 1996. It does not apply under sixth schedule. Under fifth schedule, it does apply. Moving forward, we have here temple regulation in India. Why it was in news? Karnataka Legislative Assembly passed the Karnataka Hindu Religious Institutions and Charitable Endowment Amendment Bill 2024 to regulate temples in the states. The new bill amends the Karnataka Hindu Religious Institutions and Charitable Endowments Act of 1997. Here, the bill mandates that the government will collect 10% and 5% of the income from temples that have annual revenue of more than 1 crore and 10 lakh respectively. Previously, temples earning between 5 lakh and 10 lakh annually contributed 5% of their net income to the common pool fund, while those earning above 10 lakh allocated 10%. But here, the new provisions are that if the revenue of a temple is more than 1 crore, they have to pay uh, they they have to pay 10%, and if they have 10 lakh, then they have to pay 5%. Bill proposed to utilize the money for the welfare of priests and the developments of temples whose annual income is less than 5 lakh. Moving forward, what are the legal and institutional framework to regulate temples? Here we know about Article 25, fundamental right, gives the freedom of religion, and Article 25.2 talks about areas where the state may intervene and make laws or regulate religious institutions. Article 26, which provides for the freedom to manage the religious affairs of the citizen and is subject to public order, morality, and health. Entry 28 of List 3 of Schedule 7 empowers both union and state legislatures to make laws on charities and charitable institutions, charitable and religious endowments, and religious institutions. Then we have Hindu religious and charitable endowments. Several states across the country have enacted legislative and regulatory framework to regulate these institutions through the powers accorded by the Constitution. Then we have Hindu Religious Endowments Commission 1960. The commission declared that the government control over temples was essential to prevent maladministration. Moving forward, our last article of today's discussion, it is the cinematograph certification rule 2024. We had discussed this many times, I guess, in our previous videos. If you are new, if you are watching this video first time, please go through the older videos related to polity, current affairs. You would see this topic which we had already discussed. So here we will put little touch over this article again. We will see what were the important developments under the. Let's move to it. Under the Cinematograph Amendment Act 2023, the Ministry of Information and Broadcasting, they have notified the Cinematograph Certification Rule 2024, replacing the Cinematograph Certification Rule 1983. About film certification in India, film certification is the end product of the process of previewing a film, and it includes a decision either not to allow a particular film or public viewing, or to allow it with certain deletions or modifications, or at least a proper categorization of the films. The CBFC, or the Central Board of Film Certification, was set up in Mumbai with several regional offices to regulate the public exhibition of films under provisions of the Cinematograph Act of 1952. CBFC is a statutory body under the Ministry of Information and Broadcasting. There are 9 regional offices, which we can see here: Mumbai, Chennai, Kolkata, Bengaluru, Thiruvananthapuram, Hyderabad, New Delhi, Kotak, and Guwahati. The Board of Film Certification shall also ensure that the film is judged in its entirely entirety from the point of view of its overall impact, and is examined in the light of the period depicted in the films and the contemporary standards of the country and the people to which the film relates, provided that the film does not deprave the morality of the audience. So whole different vision is given here, how it should be judged in different ways, like the impact of the movie, the period it depicts, uh, the cinematographic standards, the impact on the people, and other things which we saw there. Then the SC judgment in S. Rangarajan versus the P. Jagjivan Ram 1989 said that a film motivates thought and action and assures a high degree of attention and retention as compared to the printed words. Therefore, certification by prior restraint is not only desirable but also necessary. Moving forward, what are the key aspects in the cinematograph certification rule 2024? Here we have term of office. A member of the board shall hold office during the pleasure of the central government. Representation of women. It stipulates that 1/3 of the members in the board shall be women, and preferably half shall be women. Then we also see here the temporary absence of chairperson. Central government may nominate a member of the board who will discharge the functions of the chairperson until the chairperson resumes their duties. Then we have constitution of advisory panels. The central government shall constitute an advisory panel at each of the regional offices of the board. Then we have improved efficiency by reducing timelines for the processing of film certification and adopting complete digital process for eliminating all transactional time. It will streamline and modernize the film certification process for the digital use. Further, classification of UA subdivision of the existing UA unrestricted with the caution category into 3 more age-based categories, which we had already discussed. It will ensure young viewers are exposed to age-appropriate content. It would be voluntary. So this was about the final class related to the current affairs of polity and governance. I hope I was able to convey the information properly, and I hope you would watch all these videos, and I'm very much sure that if you had seen all these videos, it would help you in cracking few of the questions related to current affairs in your exams. You know, today we completed the whole session for the polity and governance. From today, we won't touch polity and governance. Now, tomorrow we would discuss about the last session of international affairs. Then on first onwards, we would discuss economy, ecology, and science and tech. These 3 important subjects, we would try to complete these 3 important subjects before our exams, at least before 10 to 15 days of our exams. So stay with me, and I hope after watching all these videos, you would gain the confidence to, you know, to uh, go into your exam and with full confidence and crack many questions. And I wish these videos would help you in clearing the doubts, in gaining the information about the current affairs. और दूसरी बात, if you are still with me till now, I want you to please subscribe to this YouTube channel, as it takes huge effort. You know, I know there might be many mistakes, not the content wise, but the way I convey the information. I may not be doing it the way you want to hear, but promise you guys that once I start the habit of teaching, which I am doing it from one last 1 month, I would develop the way to make you understand points way better. So this is just the beginning. Now, after our exams are over, I had already said you guys that from the 1st July only, I would take up the 2025 uh, course. You know, I would take up the target 2025 IAS exam. In that, every day I would upload the daily current affairs. Then I would upload the daily current affairs, daily questions, in which we would discuss 10 to 15 questions daily related to current affairs, related to subject which I'm going to teach in this channel. And the important questions, important concepts we would discuss. That would be like a model paper questions we would discuss, and we would discuss old questions which UPSC has asked. So we would take the all-out approach for the UPSC 2025 from 1st July. So stay with me. I would complete all the subjects separately. I would complete the We would discuss the 10 to 15 questions, and at the end of the April 2024, we would had if we would do this, if I'm able to do it, we would at least discuss 3 to 4 thousand questions from the current affairs, from the previous questions asked, and from the static portion only. That would help you in a better way to clear your prelims or your UPSC exam in 2025. So stay with me and do subscribe my channel. This would be the kind of appreciation to my work which I am putting forward, and I will promise you that I would work more harder, and I will give you more related information if you stay with me. And I wish best of luck for you guys. Thank you very much. May God bless you. May you succeed uh, in whatever dream you have. Thank you very much. Oh, sorry, we have one slide more to discuss. I waste your time. So here provisions for priority screening for expediting the screening of film, screening for certification in case of any urgency felt by filmmakers due to their prior commitment to release the film. This step is in line with the motto of ease of doing business. Then we have change of category of film for television. Certification of the edited film for television broadcasts as only unrestricted public exhibition category films can be shown on television. Then we see the perpetual validity of certificates, removal of the restriction on the validity of the certification for 10 years.